Today we are doing selection number 56, 1,275 standard words on the subject of burglary. Ready? Let's write. Gentlemen of the jury, this defendant, Herbert Powers, is charged by an indictment returned by the grand jury of this county. One count charges burglary of a dwelling in the nighttime, which is a capital offense. The other count charges grand larceny in a home from a dwelling house. However, only one count will be submitted to you for your consideration, and that is the count charging that he broke into and entered the home of Michael Durant in the nighttime. You can't convict him under both counts. You can only convict him under one count, and that is the count that will be submitted to you for your consideration. Under our system of laws, the defendant is presumed to be innocent. Every defendant that is brought into court before the bar of justice in answer for criminal transgressions is presumed under our fundamental law to be innocent, and that casts the burden upon the state to prove him guilty by the testimony beyond a reasonable doubt and to a moral certainty. Now, you have heard the testimony. You saw the witnesses as they gave their testimony. You had an opportunity to observe their demeanor upon the witness stand. Any show of nervousness or lack of it, any hesitation. Did any of them pause and hesitate while giving their answers, or did they speak out forthrightly? The law says that you may even take into consideration the facial expression of the witness as he gives his testimony in determining what weight and credibility you will accord to him. All the circumstances surrounding the witnesses in giving of his testimony, the manner of the witness, the demeanor of the witness, everything is to be considered and weighed by you in determining what probative value and force you will accord to his testimony. Now, the defendant elected to become a witness for himself and testify in this case, which he had a right to do. And you cannot capriciously cast aside his testimony. The law says that you must take his testimony and consider it along with all the testimony in the case, but that you have a right to take into consideration the fact that he is the defendant and is interested in the result of this trial. There was some evidence in this case that he was previously convicted and served a term in the penitentiary for a crime involving moral turpitude. You may consider that for one purpose only. It goes to his credibility. You may consider that testimony in determining what weight you will accord his testimony, how much credit you will accord to him as he testified in this case. You are the sole judges of the facts in this case. It is your responsibility to resolve the facts and determine what the truth is. As I said, the burden of proof is upon the state to convince you beyond a reasonable doubt. Then that calls for the question, what does it take to constitute reasonable doubt? It is not imaginary doubt. It is not a speculative doubt. It is not a fanciful doubt. But the law says that a reasonable doubt is an actual, substantial doubt, a doubt for which you can give a reason. It must be reasonably substantial doubt. The state doesn't assume the burden of showing beyond all possible doubt. Everything relating to human affairs or pertaining to human transactions is susceptible of some doubt. So our Supreme Court has ruled, and the law writers have tried to hit upon a reasonable, fair, sensible definition of a reasonable doubt. They say it is an actual and substantial doubt. Now, if the testimony in this case is such as to create in your minds a bona fide conviction of the guilt of this defendant, then you are convinced beyond all reasonable doubt, and you ought to convict him. On the other hand, if you are not as convinced, it will be your duty to acquit the defendant.